You're now a live studio audience. Okay, thank you everybody who's here and everybody who's watching at home. Obviously, today's CLE is on reviewing the grand jury minutes for dismissal motions. The genesis of this is kind of a few cases in the last 6 months or so where people have reached out and asked me to review their grand jury minutes, and we've found several errors. We've had a couple of cases dismissed. And I just think it's a good opportunity for us because we're now getting the grand jury minutes, and the benefits are obvious as far as knowing what witnesses are going to say, as far as analyzing your case for suppression issues. But the benefits aren't so obvious as far as making motions to dismiss. This is kind of new to us. We used to always just ask the court to review it, move to dismiss, and then you would get the one-page order back saying, I reviewed it and everything was great. But now we have an opportunity to do some, critical analysis of these grand jury minutes. So hopefully today can help point you guys in the right direction. We'd like to thank ILS for securing funding that allows for educational opportunities such as these. Obviously, the things that are said today are the views of the Erie County Assigned Counsel Program and not any state or federal governmental agency, including ILS. And a thanks to Dan and Michelle for supporting us when we have ideas to have seminars and things like this. It's really nice to have bosses who let you have ideas and have projects and run with them. So with that, we'll get started. Just a brief outline. We're going to talk about how and when you receive the grand jury minutes, and then we'll delve right into the motions to dismiss. So there's kind of two separate categories. There's legal insufficiency, and then there's defects in the proceedings. And there are some differences between the two as far as standards of review and things like that, so we'll talk about that. And then at the end, we'll talk about a couple little procedural bugs that sometimes can hang the DAs up. As far as receiving the minutes, you should be getting them within 20 days after arraignment on the first accusatory instrument if your client's in custody, or 35 days if out of custody. Obviously, in most cases, the grand jury presentment will be outside of this time frame, so you'll just get it as soon as it becomes available. It's not a huge problem in Erie County where there's not transcription services available, and there's no huge delay in us getting the grand jury minutes. You're usually getting them within a month after your indictment. So you will get them shortly after your indictment. The discovery statutes apply only to testimony at the grand jury, not instructions. So most prosecutors are just, to comply with discovery, are just giving you the testimony. They're not going to give you the instructions. We'll talk a little bit later about some arguments you can make to try to get the instructions. And I know some of the prosecutors are actually just giving the whole transcript, including the instructions, but I think that's the exception, not the rule, as it currently stands. One thing to remember is it applies to testimony of any witness who testified at the grand jury, not only people that they intend to call at trial. So if witness B testifies at the grand jury and the prosecution has no intention of offering this person at trial, they still have to turn over the grand jury minutes, the grand jury testimony of that witness. Since we've been getting these, I think our attorneys have been doing a great job of using them for the obvious uses, analyzing your case for suppression issues. So you're going to read through and see why the police stopped your client's vehicle, what the basis for the search was, things like that. Because once they say it on a transcript in the grand jury, they can't really change it later on. And if they do, then you'll be able to cross-examine them with their grand jury testimony. Also, other witnesses. You know what other witnesses are going to say. You know what they cannot deviate from once they do say it. So there's an obvious benefit in receiving these grand jury minutes, but That's not what today's about. Today we're going to talk about the looking through these grand jury minutes with an eye toward moving to dismiss the indictment. There are a couple statutory provisions at play. When you're moving to dismiss for insufficient evidence at the grand jury, it's governed by CPL 21021B. And when you are alleging that the grand jury proceeding was defective within the meaning of 210.35, it's governed by CPL 21021C. We're going to talk first about legal insufficiency. So this is, you're going to be looking through your grand jury minutes. You have your indictment. You know what your client's charged with. What you have to do is look through the testimony and make sure that the prosecution has covered every element of every crime that's charged in your indictment. Under CPL 190.65.1a, a grand jury can only indict a person for an offense when the evidence is legally sufficient to establish that the defendant committed that offense. And legally sufficient evidence is evidence which, admissible evidence first off, which, if accepted as true, would establish every element of the offense charged. The proof doesn't have to be beyond a reasonable doubt, but there must be a prima facie case for every element of each crime. What I like to do is make a list of the elements of each charge and check them off as I read, or use the CJI for the elements and check them off as I read. And if, when you're done reading, one of the elements isn't checked off, then you might have something to go with. You want to look back and think about it further. The evidence is viewed, just one moment, the evidence is viewed in the light most favorable to the prosecution when these are analyzed. So let's say witness B is the witness that establishes that your client entered a building unlawfully. And witness B has a rap sheet a mile long, has been given a great benefit to testify, has given 6 different inconsistent stories about what happened, and you don't think that's a credible witness. That's not a subject of a motion to dismiss an indictment under grand jury proceedings. You have to take all the testimony that was given at the grand jury as true and make your argument based on that. Yes, Dan?
You answered my question.
Okay, thank you. The standard is reasonable cause to believe rather than beyond a reasonable doubt. So it's a little bit of a higher bar when we're moving to dismiss on legal insufficiency of evidence. The court may dismiss if there's no applicable lesser included offense that would be covered, but the court can also reduce to a lesser included offense. So let's say your client's charged with burglary second, and there's no proof that the building was a dwelling at the grand jury. What the court should do in that scenario is reduce it to an indictment for burglary in the 3rd degree. The issue of legal insufficiency, there's a little bit of a problem with this. The issue is often ignored by the trial courts. And the reason is, if your client pleads guilty, or if you go to trial and then are convicted on legally sufficient evidence, any argument that the evidence supporting the indictment was insufficient is moot on appeal. So there's really no oversight with these motions. There's really no recourse when the trial judge wrongfully declines to dismiss an indictment for legal insufficiency. So that's kind of the problem, and that's why I think we always got those one-page orders of, I looked over everything and the evidence is sufficient. There's really no oversight and no way to ever attack that on appeal if the trial judge is wrong. Obviously, that's not something we want to remind the judges of or the prosecutors and advertise, but it's just something that's, I think, important for all of us to know. I think it does underscore the importance of making your best arguments before the trial judge, because that's your best and really your only chance to make these arguments that the evidence supporting the indictment is legally insufficient. Along with your written materials, Judge Franzik wrote an article. There's some case law in there about certain things that are sufficient, certain things that aren't. I can say in the last a couple of years since I've been here. A few examples of things that have been insufficient are like the value of a damaged property on a criminal mischief case, the dwelling example where it's, there's a burglary established, but it's not established that it's actually a dwelling. Things like that are things you want to look at. It's usually your discrete elements. Once in a while, maybe they'll forget to prove identity or prove that it happened in the county of Erie. Those are all things you want to make sure you're checking off as you're reviewing your grand jury minutes. Now, unlike the legal insufficiency argument, if you're arguing that there were defects in the proceedings that prejudiced your client, these survive a trial conviction and they can be argued on appeal, as long as you make the arguments and preserve them at the trial level. So if you notice a couple things, inadmissible evidence being brought in at the grand jury, or a reference to your client having a criminal record or something like that, if you don't argue that, the appellate attorney can never go back and argue that. It's not going to be preserved. But if you argue it and make a motion to dismiss, and the trial judge denies it, that will be something that the appeals attorney has in their back pocket to argue on appeal. Not that they'll always win. It's a kind of a flexible standard, which we'll get to. But, it's always good to be going into your trial with already an issue or two on appeal before you even start the thing. So it's good to make the arguments. And in some cases, you can get an indictment dismissed. It has happened multiple times in the last year in Erie County. The DAs are, very busy these days, and I don't know how much oversight they have when they're presenting cases to the grand jury. Certain cases that come through make me feel like maybe not so much oversight, especially on suppression issues and things like that. So you want to look through with a critical eye and look for defects in the proceedings. The legal standard that these are all going to be governed by is the indictment must be dismissed if it fails to conform to the requirements of Article 190 to such a degree that the integrity thereof is impaired and prejudice to the defendant may result. So to be clear, and case law supports this, it's prejudice to the defendant may result. You don't have to establish actual prejudice. You have to establish that there's a potential for prejudice to your client based on the errors that occurred in the grand jury. One little error, one little flaw isn't always going to get you there, or rarely ever going to get you there. But if you don't want to just stop at one. So you find one error in the grand jury. You don't want to just, okay, great, I got it, I'm going to make a motion to dismiss. You want to look for other errors, because when you're talking about prejudice to your client, obviously you want to start thinking about the cumulative effect of multiple errors that could happen. And if you have 5 or 6 errors, one's kind of a big deal, the rest aren't really that big of a deal, you still want to include the ones that aren't that big of a deal, because it's the cumulative effect of all the errors that would cause prejudice to your client. We have the first code here. For those who are here, you don't have to write this down. You're here. We can see you here. For the people at home, the first code is quorum, Quorum, quorum. One thing that attorneys will often ask me about is what duty does the prosecution have to present exculpatory evidence to a grand jury? So if they have a statement from a witness who says, someone else did the crime, or he was allowed in my house, it wasn't a burglary, something like that. Does the prosecution have to present that evidence? And the answer is not always, but sometimes. The answer, I guess, more accurately would be rarely does the prosecution have a duty, but it is an argument we can make. And I'll kind of give you the legal standard, and we'll talk about what some examples would be. So generally, the prosecution has wide latitude in deciding what to present and what not to present. However, the prosecutor, this is the one quote that gives us the opportunity to make an argument. The prosecutor must be mindful that the role of the grand jury is not only to investigate criminal activity, to see whether criminal charges are warranted, but also to protect individuals from needless and unfounded charges. So some courts have taken that to mean if there's evidence of a complete exculpatory defense, like identity, justification, something like that, that would eliminate any grounds for prosecution, that exculpatory evidence should be presented to the grand jury by the prosecutor, because it could prevent a needless and unfounded prosecution of an individual. Now, if it's a mitigating defense like extreme emotional disturbance, so let's say you have a murder case, a guy killed his wife, and there's evidence that he had just found on her phone text messages between someone she was having an affair with, the prosecution wouldn't have to present that to the grand jury because it's not a complete defense. It wouldn't absolve him of any criminal liability. It would merely mitigate the offense, the degree of offense that he would be guilty of. So that's how some courts have taken it, that they do have to present exculpatory evidence when it would eliminate any prosecution whatsoever. But when it's only mitigating, whether it's degree or mitigating punishment, they don't have to do it. Even getting there is tough because some courts just, cite Mitchell and say the prosecution has wide latitude. They don't have to present anything they don't want to present. But this is an argument that we should all be aware of and an argument that we should all be ready to make if you know of exculpatory evidence that was not presented at the grand jury. This is a big one, and this is one that has worked in the past. I've even personally had indictments dismissed on this argument, and I don't think a lot of people know. So this is an opportunity you're going to have in your case, especially if your client makes a statement. When I worked at the DA's office, I tried to get everybody to listen to this and to be aware of it, and they would look at me like I had three heads. So I don't think prosecutors are thinking in these terms, but the case law is very clear on this. To be clear, the prosecutor never has to admit your client's statement at the grand jury. It's completely up to them. Now, if the statement gives rise to a justification defense, when we go back to the last slide, you can make this argument, but it's by no means a guaranteed winner. It's by no means the strongest argument you're going to make. But once they do choose to admit your client's statement, they have to admit the whole statement. So if we look at People v. Falcon, what happened there is the defendant gave a one-page written statement, very quick statement, and then they took a long videotape statement where he gave a lot more details, and there were inculpatory and exculpatory remarks made during it. It was a little more nuanced. It would give rise to potentially a defense. And what the prosecutor did at the grand jury was they only presented the written statement. That indictment was dismissed, and the First Department upheld the dismissal of that indictment. And what the First Department said was they didn't have to use the statement at all in the grand jury, but once they chose to, they had to use the entire statement and not just the parts they wanted to use. People v. Isla, again, the prosecutor offered half of the defendant's statement to a grand jury. This one was, I believe it was a justification case. I think it was a shooting or some kind of assault. And the defendant admits to causing the harm to the individual, but then talks about how it was justified. And they only offered the part where the defendant admitted causing the harm at the grand jury. And the First Department gave some strong language in this case, and they said, it seems more than just a little unfair for the people's attorney not to have disclosed the whole of the defendant's confession. The grand jury was entitled to the full story so that it could make an independent decision that probable cause existed to support the indictment. Back in my first stint as a criminal defense attorney, I got Judge Bowler to dismiss an indictment on the first day of trial making this argument. Because remember, back then we didn't get the grand jury minutes till the first day of trial. And when I got them, I was ready to make this argument. I made it, and he dismissed the case. It might be because he wasn't looking forward to having a trial all week, but at least I gave him something that he could do. So, and in that case, what happened was it was a sex case, and he admitted to having sex with the complainant, but then he went on. It was like a 45-minute statement reduced to writing, where he talked about how it was consensual and it was a date and blah blah blah. And what they did was, instead of offering any of the statement, they just threw the detective at the grand jury, had the detective give a synopsis. And the detective said, yeah, he said he admitted he had sex, but said that it was enforceable. And I was able to say, well, he said a lot more than that in his statement. He gave reasons why it was enforceable. He gave, it was a 45-minute long statement. So they didn't have to use it at all. But once they chose to, they can't just pick and choose the parts that they wish. They have to use the whole thing. And that's an argument that I don't think prosecutors are very aware of, and it's an argument that I think has very good support in the case law, so it's something to be aware of. Evidence errors. The rules of trial evidence apply at grand jury proceedings. That's absent a couple exceptions that we'll get to, I believe, on the next slide. But in general, the rules of evidence at trial apply to grand jury proceedings. So when you read through the grand jury minutes, if you're seeing hearsay questions, if you're seeing documents being admitted without an adequate foundation, those are all errors that you can point to and argue that the grand jury presentment there were irregularities and prejudice to your client may result. Once you establish these evidentiary errors, all you have to establish is that, quote, prejudice to the defendant may result. So when you're looking through, you want to look for hearsay, you want to look for anything that's admitted without a foundation.
Nick,
Yes.
Are there any cases where an argument of evidentiary irregularity resulted in dismissal?
Yes. So there's this
You
people.
don't have to recite them.
Yeah, there's this People v. Dunn case right here. But in Judge Franzik's supplement to the written materials, he goes through some specific case situations where it does happen. A lot of times you'll point to these errors and you'll make the argument, and the judge will say, yeah, technically that was hearsay, but there's really no prejudice here. There was a ton of other proof, and oftentimes the remedy will be they'll excise the hearsay evidence and then analyze the sufficiency without it. And if the evidence is still sufficient, it'll be fine. But if removing the hearsay evidence renders the evidence insufficient, then the indictment will need to be dismissed. I think we have a question from someone at home. The question was, what about leading questions? Yeah, it's the same thing. It's really any evidence error, anything that you would object to at trial and you think the judge would be on your side about. So if they're asking a ton of leading questions, they're going to get a little more leeway if it's, let's say, a vulnerable victim, like a child sex case or a really elderly person or something like that. They're going to get a little bit more leeway and be able to ask some more leading questions. But it's an argument you can make for sure. You can always... really, the thing I want to stress is anything that would be an evidentiary error at trial is also an evidentiary error at grand jury, except for the exceptions. So it's the same exceptions that you all know from felony hearings. It's affidavits of ownership, lab reports, things like that. They can just lay a foundation, enter it into evidence. They don't need a live witness. But for the most part, if you're looking at evidentiary errors, it's the same rules that are applicable at trial. Now, I talked about the remedy, and it's to take away any improper hearsay evidence and then review for sufficiency without that evidence. Because remember, we talked about what the standard is, and the indictment has to be based upon competent evidence, which, if true, would establish every element. So you're going to remove the incompetent evidence, the stuff that should not have been admitted, and then analyze it that way. But I think if you have a number of errors, it can go beyond that. Because you can say, look, yeah, it's all well and good to take out this hearsay evidence and then analyze it, but just given how powerful it was and how weak the evidence is without it, who knows if the grand jury would have even indicted without this evidence. Yeah, we can say it's legally sufficient, but it's still an irregularity that caused the defendant prejudice. So that's an argument you can still make for sure, especially when you have a lot of errors. Another one is Trowbridge, and this is one that we got an indictment dismissed in the past year on this. It was a case, Jessica Culpet had it, and she identified some issues in the grand jury. And what happened was, this is a photo array case. And what the prosecution is supposed to do is call the detective to say, yeah, I made this photo array. The defendant, John Smith, is in slot 5. And then another detective to say, yeah, I administered this photo array. The victim made a selection. Can't say what the selection is. And then only the victim can say, yes, I chose the person in slot 5. If they have a detective say who the person viewing the array chose, that's what's called a Trowbridge error. It's hearsay, it's bolstering, and it is a serious error that can result in dismissal of your indictment. Or there are cases where it results in reversal of a trial conviction if it happens at trial. It's a very serious error. And again, this was successful in the past year on an attempted murder case in getting an indictment dismissed. So that's something to always look for when they're using photo array evidence in the grand jury. Only the person who made the selection can testify as to who they selected, not the detective. This comes up a lot in the grand jury because a lot of times the prosecutor isn't getting the level of cooperation that they were hoping to get out of certain witnesses they put in. And then they're going to start cross-examining that witness and start being a little more aggressive with that witness and being tougher on that witness and trying to get them to give an account that's a little more helpful to the prosecution. The rules on this are very, very strict. So a prosecutor may not cross-examine his or her own witness unless that witness, number one, has made a prior sworn statement or oral statement under oath that contradicts his or her testimony, and two, that the testimony tends to disprove the position of the party. And the case law is very strong on this, that an I don't know, or I don't remember, or I didn't see anything, I don't know what you're talking about, that doesn't qualify as tends to disprove. What would qualify as tends to disprove is, no, it wasn't the defendant, Sean Kelly, who shot the victim. It was this other guy, Tom Whitehan, who came from down the street, right? That would tend to disprove the theory of the prosecution. But just, I don't know, I didn't see it. I didn't see anything. I don't know what you're talking about. I wasn't even there. That doesn't tend to disprove the position of the party. So when someone says that, the prosecutor 99 times out of 100 will start to cross-examine that person. And they cannot do that. They're not allowed to. and that's the basis for a motion to dismiss the indictment. Dan, you had a question?
Does every time where a witness at the grand jury changes their sworn testimony, or their testimony that was sworn to before and then changes it on the stand, is that always a case where the witness gets arrested for perjury, and charged with perjury?
Okay, the question was, in every instance where a witness changes their testimony at the grand jury from a prior sworn statement, in every case is that witness then charged with perjury after their grand jury testimony? Not in every case. I would say if it's a material issue, if it's a serious case, the prosecution will, the DA's office will end up charging that person. But not in every instance. Sometimes it just happens and they have to move on to the next case because it's just a, what's that?
Does that include law enforcement?
Well, exactly. You know, and the question was kind of a tongue-in-cheek question, but I think a serious one too, which is, does that include law enforcement when they change their testimony? And it's funny how defense witnesses will often be charged with perjury when their story changes, but law enforcement officers often change their stories, and there's not even not only are they not charged with perjury, but their new testimony is taken as credible and believed and forms the basis for denial of your suppression motion or conviction of your client. So it's a good point. But no, the answer is they won't always charge a witness with perjury. But if you're representing a witness, you certainly don't want to take it as a given that they're not going to charge that person with perjury. I think in a lot of cases they will. It's something they take very seriously. They want the testimony they want, that they feel they're entitled to based on the prior statement. So it's something that the prosecution will very often consider doing. But not every inconsistency allows the prosecution to even cross-examine that witness. So, you know, if it's not material, number one, or if it's not damaging to their case. So if it's just some innocuous thing like, you know, 6 police cars showed up, and it was actually, they said before 4 police cars showed up. That's not going to affirmatively damage the prosecution's case. It's not material, really. So they're not going to be able to then cross-examine the witness on that point. But again, it's more for the situation of, no, it wasn't the defendant, John Angie, who hit the guy with a baseball bat. It was this other guy who came down the street. That's what it's going to be. And they will do it because, you know, prosecutors aren't perfect. They're subject to the same, you know, feelings and thoughts that any human would have. And when they know someone is, or they feel that someone is sitting there lying to them and it's hurting their case or not giving them the punch that they wanted out of that witness, they're going to want to correct that because they're nervous. They want to get their indictment. They don't want this whole thing to go south. So they're going to try to correct it, and they're going to try to cross-examine. So it is something that you will come across from time to time, especially when you have a lot of witnesses who are uncooperative or witnesses who are cooperating but only because they feel that they have to, things like that. Prejudicial evidence. What I attached with your written materials was an order from Judge DiTullio on actually another Jessica Culpit case where she reached out to me for assistance in reviewing the grand jury minutes. But what happened in that case is, you know, they're talking about when the defendant was apprehended, and the officer said, yeah, you know, I had some old mug shots of her, and I was, you know, figuring out who it was. And then later talks about some murder investigation dealing with that address. And they did give a curative instruction, but Judge DiTullio did a really good analysis, and, you know, it talked about the prejudice, because even at trial, if that stuff comes out, that can be grounds for a mistrial. It can be grounds for a reversal of a conviction on appeal. And the judge talked about how serious of an error that is. But what the judge also talked about was it's not like this was a completely rock-solid case in the grand jury. Sure, there was sufficient evidence, but it wasn't a very strong case. And that's important because remember, the whole question is there a potential that prejudice to your client was the result? And the weaker the evidence is at the grand jury, the higher likelihood that prejudice to your client resulted as a result of whatever the improper conduct was at the grand jury. So you can take a look through that decision. I did redact the name of the client because I believe that she was ultimately probably not convicted of anything, so that'll be sealed. So, but you take a look at the decision because it gives you kind of an eye into how at least one of our local judges sees these type of issues. Anything involving prior criminal involvement, mugshots, anything that indicates that they have a prior record, it's the same rules that apply at trial. So if you have something that you think is an error or prejudicial to your client at the grand jury, you can, when you're doing your legal research, any case that says it's a trial error can then be extrapolated to say it's also a grand jury error. When you look at, all you have to do in order to make that extrapolation is cite CPL 19030, which says the same rules apply at trial as they do at grand jury. So it makes your legal research a little easier. It makes it easier to find cases because you don't have to find a case where someone says it's improper at the grand jury. All you have to do is find a case where someone says it's improper at trial. Cross-examination's a little bit different of a defendant because, we all know when your client takes the stand at trial, you get the Sandoval ruling, and the prosecutor can ask them about some of their prior criminal involvement, but not all of it. It's subject to regular Sandoval rules. So what the prosecutor can do before your client takes the stand in the grand jury is request a ruling from special term, or what the prosecutor usually will do is use their own discretion and just ask about a couple of them. But that's always an argument you can make, is that the prosecution went above and beyond what a Sandoval ruling would have been in the case when they were cross-examining your client on their prior bad acts. I want to talk briefly about notice because this does come up sometimes. What I used to do and what I always do whenever I do have a case, I know you guys are now doing the notice of appearance so that they know where to send discovery. If the case is not yet indicted, I would always just do a 19050 notice too, just saying, my client wants to testify in the grand jury. Because what that allows you to do, it doesn't require your client to testify in the grand jury, but it allows you to monitor things. Because then they're going to have to give you a notice. They're going to have to say, look, we're presenting at such and such a date. It's going to then jog your memory. Oh, I meant to ask the prosecution if they were going to call X, Y, and Z witness. Or if you haven't talked to your client yet about testifying in the grand jury, it puts that bug in your ear to go talk to them about it, or to have them in the office to talk to them about it. So it allows you to monitor developments in your case a little better. Because if you don't do a 19050 notice, the prosecution in most of your cases will not be required to provide you with notice that the case is about to be presented. Here in Erie County, they often do, but sometimes when they're under the 8-ball and running really quickly, they won't because they know they don't have to. The only time they have to, if you don't do a 19050 notice, is if there is a currently undisposed of felony complaint pending in the lower court. So if it's a misdemeanor pending in the lower court and they're going to present it to a grand jury, they don't have to give you any notice. If it's a case that you waived for the grand jury, technically, they don't need to give you any notice. If it's a case that was dismissed for direct, they don't have to give you any notice. Unless you give them just a written document that you can just keep one on your computer and change the client's name and file number. And if you give that to them, that triggers a notice requirement. One thing to keep in mind, because this is something we get asked sometimes, and it's a little counterintuitive, but the choice of whether your client testifies or not in the grand jury is actually your choice, not your client's choice. At trial, it's your client's choice. Now, obviously, you can take your client's wishes into account when you're making your own decision, and the level of weight that each attorney is going to give their client's preference can vary. But what you cannot do is completely abrogate that decision to your client. It actually is ultimately your choice whether your client testifies in the grand jury or not. In a case that you feel you were not given proper notice of a grand jury presentment, you have to move to dismiss within 5 days after the arraignment on the indictment. So, and that's very strict. I've never seen a motion granted where it was untimely in that way. So in a case where you don't think you got the proper notice, you have to get that motion out right away.
You mean the Friday afternoon, Monday morning testimony? Usually give you the notice Friday afternoon at 5
Right.
o'clock, but you have to be there with your client 9 o'clock Monday morning.
Right, yeah, and what Mark said for the people at home is sometimes you'll get notice 5 o'clock on Friday afternoon that your client has to be there 9 o'clock Monday morning. Depending on the circumstances, that could be an argument that that's insufficient notice. The cases kind of go both ways. Sometimes I've seen as little as 24 hours be enough notice. I've seen as much as 48 hours not be enough notice. So you have to make those arguments based on the circumstances of the case. But if you are making those arguments, the really important thing is you have to make that motion within 5 days after the arraignment on the indictment, or they're never going to get to the merits of it. We're at the second code. The second code for the people at home is VOTE, V-O-T-E. For those of you who are here, don't worry about it. But for those at home, it's VOTE, V-O-T-E. Just using grand jury words, as codes, quorum and vote. What are you going to do? A couple other little procedural things that you want to think about. Appearing in shackles. So if your client wants to testify and they're going to make him stay in complete shackles during the testimony, number one, you have to object to it or you waive the issue. So you have to say, no, hold on, I don't want these shackles on, we have to go up to special term. I got to make this argument. If you don't do that, you waive the issue completely. You're deemed to have consented to your client being in shackles. And in this Richardson case, what the appeals attorney did was say, well, okay, I understand we waived the issue. Well, then defense counsel was ineffective for waiving the issue, for not making the argument. And the Fourth Department rejected that too. They said, no, it doesn't really rise to the level of ineffectiveness. So you're going to lose that issue forever if you don't make the argument right away. Yes, Sean?
If they try that, and you make the objection go up to special term, and they say, okay, you don't have to appear in shackles, and they send it back down, and this time your defendant's not in shackles, can you make the argument that the damage is already done?
Well, you should object, I guess, before he's brought into the room. You're going to be sitting in a room off to the side with your client waiting to be called in. And when they
You
come,
bring him in, and you see he's in shackles, you make your objection, but the grand jury's already seen it.
well, he's not going into the actual grand jury room unless you're in there with him. And usually you'll be in a private room with him, so it's not like anyone's staring at him. But grand jurors do kind of come and go. And if you notice them walking through and seeing your client and taking a look, yeah, you can make a record of that in special term and say, look, damage is already done. They've already seen it. They should have to present this to a different grand jury. You can make that argument. I don't know if it's going to go anywhere.
Shackles, does that just include handcuffs, or when they're actually shackled?
No, it includes handcuffs in the front. It includes, the leg restraints, whatever they are. And basically the prosecutor has to show that under the circumstances of this particular case that there's a need for the restraints. So it can't just be like, yeah, well, of course, this is a murder case. He killed somebody. We need restraints. No, it has to be something particular about this defendant. Did he try to escape from the holding center? Does he have an indictment pending for assaulting a guard at the holding center? Did he punch his last attorney in the face? Whatever it is, the prosecutor is going to have some reason something that your client has done to support their argument that restraints are needed. I know a lot of the DA investigators are just like, no, I want the restraints on him or I'm not doing it. Or that's how they used to be. So sometimes the prosecutors will just try to, they're like any of us, they're trying to sometimes take the path of least resistance. So if you're not going to make the argument and their investigator is, they're going to go with that side. So if you want to protect your client's rights in that way, just make sure you make the argument, go up to special term so you can at least make the argument that there's not an adequate basis for it. So we talked earlier about how you're generally, depending on the prosecutor, but generally you're only going to get the testimony that was elicited at the grand jury, not the instructions that they gave at the end of the case. I don't see what the harm in giving you the instructions would be, because it's not like that's private or anything crazy. But they usually just don't do it because it's not in the discovery statute that they have to. So what you want to do is, in your omnibus motion or in some other motion later, you cite CPL 21030 sub 3. And in that statute, it says that the court is authorized to release the grand jury minutes or portions thereof to the defense if such release is necessary to assist the court in making its determination. So if you're reading through the testimony and you say, okay, there's some evidence here of intoxication that would negate intent, or there's some evidence of justification, there's some evidence of, whatever it is, it should be ringing in your head. I wonder if the prosecutor gave that justification instruction. Because if there is evidence of justification in a case, or any complete defense that would completely absolve your client of responsibility, they have to give that instruction. And again, this is something that they don't always do. They're not always thinking in those terms. They're just reading from the CJI what the charges they want your guy indicted on are, and they're not thinking about what else do I have to do here. So it can be another fruitful area. So what you want to do is, let's say you don't have the instructions. You want to make a motion to dismiss, arguing that, number one, you should give me the instructions because obviously this is something that needs to be looked into. Number two, if they did not give the justification instruction or whatever instruction it is, that dismissal would be required. Also, if there are prejudicial comments, you can ask for the instructions so that you can determine if a cautionary instruction was given. One that was getting screwed up a lot a couple of years ago, I don't know if it still is, they'll sometimes forget to instruct on the home or place of business exception on a gun case. That renders the indictment defective. So if you have a gun case, you want to make sure, or at the very least, if the court's not going to give you the instructions, ask the court specifically to look at that, whether the home or place of business exception was charged in the grand jury. It should be, and I don't know if it is, but it should be a little easier at this point to get the instructions than it ever has been. Because before, the court didn't want to turn over the grand jury minutes. I think once in a while a judge would give you the minutes here and there if they thought there was an issue, but it was really, really rare. But now you're getting all the testimony, and that's kind of the only part that should give anyone any pause. Because the whole line of thinking was, oh, they're going to have all this witness testimony, and these witnesses are going to start getting shot left and right, dropping like flies. Well, now we have the witness testimony, so what harm is it really to just give us the instructions so that we can do our job and make the right arguments? So it shouldn't really be that hard to convince a court to authorize release of those, but I think it is still. It's just an older way of thinking, and but I think we should keep making the argument and trying to get these instructions because, the whole spirit of all these discovery rules where they want us to be able to do our jobs better. And for us to be able to critically look through the grand jury minutes and make the right arguments, we sometimes need the instructions. Sometimes the arguments are dependent on whether certain instructions were or were not given. So it's, those are arguments that you can make to the judge. It's their legal authority for releasing them to you is CPL 21030 sub 3. So see if you can make any hay with that. Then before we finish, just a brief note on successive presentments, because you want to just keep these things in mind. If somebody was no-billed, the prosecution can't just go back to that same or another grand jury and present the same case and hope for a different result. There's a procedure they have to follow in order to do that. They have to obtain court permission to represent, and that's under CPL 19075 sub 3. And it's not just there for the asking. The court can only grant permission if there's newly discovered evidence that could not have been discovered with due diligence prior to the first presentment. So the common way they would get around this is witnesses lied, or witnesses gave one story in the first presentment. It ended up being no-billed. Then after a while, you assign those witnesses lawyers, negotiations, they're charged with perjury. They agree to cooperate and tell the truth. Now, what the prosecutor has to do is go ask for court permission to represent to another grand jury. Their basis is going to be, look, these witnesses just started telling the truth today. That was not available to us with any type of diligence at the time of the first presentment. We couldn't control what they said. So now we should be able to present again. But if it's just, well, we went out and got an accident reconstruction report now, and now we have better evidence that the defendant's guilty of this vehicular homicide. Well, why couldn't you have gotten the accident reconstruction report before the first presentment? You didn't establish due diligence, or you didn't exercise due diligence before your first presentment, so you should not be able to present a second time. And then the other thing to look at, if a court dismisses on the grand jury minutes, and, usually in those cases, you'll either get a better plea offer or the prosecutor will represent. And if they represent the case, what you want to do is look at the original order and make sure that the court grants leave to represent to another grand jury. Because if they don't, there's some authority, some case law, that it is deemed that they were not given that authority or that permission by the court. So I think most judges in Erie County will, the last provision where it says so ordered, it'll say that the indictment is dismissed with leave to present to another grand jury. But if that's not the case, you will have an argument that the next presentment was unlawful. And, the only other couple things to think about are if you're looking through when grand jurors are asking questions at the end of a witness's testimony, did the prosecutor go too far in answering those questions or having the witness answer them, or not go far enough? Any comments by the prosecutor which would indicate that they want the grand jury to vote one way or another, those are more misconduct arguments. Those are always arguments you can make. So we've made it, our full hour. Are there any questions from either the people here or the people who are watching at home? Okay. No questions? Thank you very much.